on. Just out of interest, I was in New Zealand recently for a body corporate lawyers conference, and it was quite interesting that there was body corporate lawyers from around Australia and from New Zealand, and the issues that body corporates face in Queensland are absolutely universal issues. They're faced by bodies corporate in all states of Australia and certainly in New Zealand. And in New Zealand, community titling is becoming more and more prevalent, and particularly in Auckland. But one thing that I didn't know before the conference, and I do know now, is that in New South Wales you can actually opt out by a particular, I think it's a special resolution, I'm not 100% certain, but a body corporate can opt out of maintaining parts of its common property. That privilege or that right doesn't exist in Queensland. We simply must maintain our common property. And that's enshrined in section 59 of the legislation, and it's a very clear statement. The body corporate must maintain common property in good condition, including to the extent that common property is structural in nature, in a structurally sound condition. Now, it's the use of the word must in our legislation which places a mandatory obligation on body corporates to maintain their common property. The question which flows from that mandatory obligation is, what is common property? Now, generally, the position, well, not generally, the position is common property is anything, any freehold land forming part of the scheme, but not forming part of the lot. So, by and large, it's going to be fairly obvious to all concerned what's common property and what isn't common property. There will be occasions where it's not patently obvious. Sometimes we get issues with balconies where we can't easily discern where the boundary is. Sometimes we get issues with standard format plans with, you know, where is the boundary of the lot as compared to the common property of the land. Common property of the scheme. When we get those issues, sometimes we just simply need to call a surveyor to either interpret the plan, or worst case scenario is we attend on site with the surveyor, and the surveyor says, well, you know, there's the boundary of the lot, so anything, you know, to its right is the common property of the scheme. Once we know where the common property starts and finishes, we can then give advice to the body corporate on whether the defect that we're looking at is a body corporate responsibility or a lot owner's responsibility. Right, if we talk about building format plans, and remember they're the ones that, for purposes of today, we'll just describe as the vertical unit developments. In addition to having an obligation to repair and maintain common property, the body corporate legislation also places additional obligations on a body corporate to repair and maintain certain other things. And those certain other things are listed in the legislation, and they're in your notes, but we'll go through them. The body corporate in a building format plan has an obligation to maintain in good condition railings, parapets and balustrades on the boundary of a lot and common property. So again, we come back to that concept of the body corporate's obligations exist really where the boundary line is of the lot. So if, for example, you might have a balustrade on a balcony, and that balustrade is inside the boundary of the lot, then technically that's not the body corporate's problem. The balustrade must be on the boundary of the lot for it to be a body corporate issue. Building format plan, the body corporate's also got responsibility for doors, windows and associated fittings situated in a boundary wall separating a lot from common property. So again, we've got this concept of separating the lot from the common property. So always have in your mind, you know, is the window essentially on the boundary line between the lot and the common property? If the answer to that question is yes, then any repairs and maintenance to that is going to be a body corporate responsibility. One thing that often comes up with that obligation to maintain doors, windows and associated fittings is you might have a garage roller door which sits on the boundary of a lot and common property, and within that garage remote control door you'll have the motor. We often get asked, whose responsibility is it to maintain that motor? Well, if that garage door is on the boundary line between a lot and common property, then that motor is, in my view, an associated fitting, and therefore it's the body corporate's responsibility to maintain. So what I'll try and do today is give you some practical examples of what comes across my desk on a day-to-day basis, and that's certainly one that comes across quite regularly. Doesn't come across as regularly as the next one, which comes across with monotonous regularity, and that is the body corporate's obligation to maintain roofing membranes that provide protection for lots and common property. I often ask myself and ask others whether the pyramids were watertight, because in the last 2,000 years we don't seem to be able to construct a watertight building. We would get asked at least, I would say conservatively, 4 times a week to advise bodies corporate on their obligations with respect to water penetration into buildings. It's a massive problem, and we were only at a building yesterday where they're actually talking about essentially terminating the scheme because the repair to the buildings are so large that it might actually be more cost effective for the insurer to buy all of the lots and just essentially bulldoze the building. It is a massive, massive problem. And it's also a fertile ground for disputes between owners and body corporates, regrettably. Now, my view, for what it's worth, is, and it seems to be supported by decisions out of the Adjudicator's Office and QCAT, but again, it's only my view, I think the baseline position for us all should be, unless there is undoubted evidence that an owner, through their actions, has pierced the waterproofing membrane, it seems to be that the body corporate is going to be held responsible for repairing that waterproofing membrane. Now, there was a school of thought a little while ago that, well, the body corporate's obligation is to repair and maintain common property. How can it repair and maintain a waterproofing membrane? It either fails or it works. There's no repair and maintenance of it. The courts have decided that yes, it either fails or it works, but it's going to be the body corporate's role to fix it when it fails. And we'll have a chat about that later on as well. That said, if in carrying out those repairs, the body corporate can establish that the acts of the owner pierced the membrane. For example, the owner may have laid new tiles on its balcony, pierced the waterproofing membrane, and then it's dripping down to the unit below. If there's irrefutable evidence that that in laying those tiles the owner pierced the membrane, then of course the body corporate does have the rights under the legislation to seek recovery of its costs from the owner. Now, my view is though that the body corporate should still attend to repairs and maintenance because of that strict liability, and particularly where that liability might flow to the committee members individually, and then seek recovery proceedings from the owners. Unless it's absolutely categorically the case that the owner caused the damage, I think the body corporate should do their job first and then go to the owner to seek recovery. I don't think the body corporate should say, no, not our problem, it's the owner's problem. Because with the delay in this type of defect, the damage just gets worse and worse and worse, and the potential liability to a body corporate is obviously increased. Foundation structures is a body corporate responsibility in a building format plan, roofing structures and essential supporting framework. So when a matter comes across my desk, the question is the body corporate responsible for this, or is the owner responsible? The first thing I ask is, okay, what type of plan is it? It's a building format plan. We're responsible for repair and maintenance of common property. When I say we're, the body corporate's responsible. Then I go through the other items that a body corporate's responsible for in a building format plan. And if we tick any of those items, then it's the body corporate's responsibility to repair and maintain, subject to what I said before. They do have a right to recover if the owner has caused any damage to that common property. In addition to repairing and maintaining common property, body corporate's also got a responsibility to repair and maintain its utility infrastructure, except utility infrastructure that services only one lot. For example, you might have a hot water system or an air conditioner that services one lot only. That's the owner's responsibility. Also, the exceptions are where that utility infrastructure is within the boundaries and is not within a boundary structure for a lot. Every time I read that, it does my head in. I've got to read it 13 times to exactly work out exactly what they're meaning. But essentially the example that the Commissioner's Office gives is that if a cold water pipe is located in a wall between a bathroom and a toilet, then that's the lot owner's responsibility. This is where it's dangerous when you're getting taped. You may misspeak like that and it's on the video forever and ever. So cold water pipes located in a wall between a bathroom and a bedroom, for example, that's going to be the owner's responsibility. But if that cold water pipe is located in the slab between the 5th and 6th floor, then that's going to be the body corporate's responsibility to fix. So, with respect to these issues, again, I'll repeat throughout, it is a strict statutory duty to repair and maintain the common property. And a failure by the body corporate to do that will have serious consequences for the body corporate and potentially for the committee members. Now, with respect to building format plans, I've given you some examples in the paper of where it's the body corporate responsibility. Maintenance of the outside of the building, painting, for example, that's going to be a body corporate responsibility. Garage doors and associated fittings, where those doors are between the boundary of a lot and common property, doors and windows in a boundary wall. Lawns and gardens in common property. This always comes up a little bit, particularly with schemes where there's caretakers. The body corporate's responsibility is to repair and maintain its common property. Often we'll get asked by a body corporate, well, what about the nature strip out the front? Nature strip out the front, it's not common property, so therefore you can't ask the caretaker, where the duty under the caretaking agreement is to simply repair and maintain common property and mow common property lawns, for example, to mow that nature strip. If you put in the caretaking agreement an obligation to mow the nature strip, then I think, yes, the caretaker will be responsible for that, because that's a contractual obligation then on the caretaker. Again, for what it's worth, most good caretakers, in my view, will simply mow the nature strip. Some, however, and it depends on how large it is and how much time it takes, I guess, but some will simply get in Jim's mowing to mow the nature strip and on-charge that to the body corporate. But I give that as an example of something that comes up regularly.